You may be seated. Now, Miss Obi, do you understand the gravity of the oath you are about to take?
The courtroom had already emptied its patience by the time the bailiff called the final witness of the day, and nobody in that room expected the final witness to be 7 years old. Her name was Adaeze, and she walked to the front of the courtroom in a wheelchair her mother pushed slowly across the tile floor, past rows of people who had come to watch a man named Emeka Obi be sentenced for a crime the newspapers had already convicted him of, a month before the trial began. Emeka sat at the defense table in a suit that didn't quite fit him anymore because he had lost 11 pounds in the 4 months since his arrest, and he kept his eyes on his daughter the entire time she crossed that floor, as if looking away from her for even a second might cause the whole fragile arrangement of the morning to collapse. Judge Harmon Whitfield had presided over that courtroom for 19 years, and in 19 years he had developed a reputation for two things: an almost mechanical fairness that neither the prosecution nor the defense could ever quite predict, and a total absence of patience for theater. He had seen grieving mothers, sobbing wives, elderly parents brought in on stretchers to testify to a defendant's good character. He had learned, the hard way, early in his career, that a courtroom could be turned into a stage, and that the surest way to lose sight of justice was to let yourself be moved by a performance instead of a fact. So when the defense attorney called Adaeze to the stand, Judge Whitfield's first instinct, which he did not bother to hide, was irritation. "Counsel," he said, "I want to understand what testimony a 7-year-old child can offer this court that speaks to the facts of this case." The defense attorney, a young woman named Priya Chandrasekaran, who had taken this case for almost no money because she believed, against all the available evidence, that Emeka Obi was innocent, simply said, "Your Honor, I'd ask the court's indulgence. She asked to speak. Not because I called her, because she asked." Judge Whitfield studied the small girl for a long moment. She was sitting in a manual wheelchair, her legs held in braces that were visible beneath the hem of her dress, and there was something in the stillness of her face that did not match the nervous fidgeting he expected from a child in a courtroom. She looked, if anything, like she had been waiting a long time for someone to finally ask her the right question. "5 minutes," the judge said. "That's what I'll give her. Go ahead, young lady." Adaeze Obi had been born with a condition in her spine that doctors described, in the flat clinical language doctors use when they want to prepare a family for disappointment, as unlikely to ever allow independent movement of her lower body. Her father had spent 6 years since her diagnosis working 2 jobs, one during the day, loading trucks at a shipping warehouse, one at night driving for a rideshare company. Every extra dollar funneled into a single fund with a single purpose: a specialized surgical procedure performed by only 4 surgeons in the world, one of whom had a clinic 4 hours away, and had finally, after years of consultations and denied insurance claims, agreed to perform it. The surgery cost more money than Emeka would make in a decade at either of his jobs combined. He had done what desperate fathers have done throughout the entire history of desperate fathers. He had taken a risk he shouldn't have taken, agreeing to drive a delivery for a man at his warehouse who promised him $4,000 for a single night's work. No questions, no details, just drive a van from one location to another, and don't look inside it. The van, it turned out, had been carrying property reported stolen from a shipping container 3 days earlier. Emeka swore, from the moment of his arrest through every single day of the trial that followed, that he had not known what was in the van, that he had been a desperate man handed an opportunity that asked no questions because it knew he was too desperate to ask any of his own. The prosecution's case rested almost entirely on the fact that nobody hands a stranger $4,000 to drive an empty van, and a jury of 12 people had spent 3 days already leaning, visibly, toward believing exactly that. Adaeze did not know any of this legal architecture. She only knew one thing with the total, uncomplicated certainty that only a child can hold on to in a room full of adults who have all, in their own ways, stopped believing in simple things. "My daddy didn't know what was in that van," she said, her voice smaller than the microphone in front of her, so that the entire courtroom had to lean forward slightly to hear it. "He told me every single night, when he came home so tired he couldn't hardly stand up straight, that the money he was saving was going to fix my legs. He never once told me a lie in my whole life. Not one time. So I know he's not lying now." A ripple of something, not quite laughter, but something dismissive and pitying, the sound adults make when they've decided a child's testimony is sweet rather than credible, moved through the gallery. Judge Whitfield actually did laugh, a short, surprised exhale more than an actual laugh, the kind of sound a tired man makes when he's heard an argument so far outside the bounds of legal reasoning that his brain doesn't quite know how to file it. "Young lady," he said, not unkindly, "I understand you love your father very much, and there's nothing wrong with that. But this court can't decide a case based on a daughter's faith in her daddy. We need facts." Adaeze looked directly at him, and something in her expression made the laughter in the gallery die out entirely, replaced by an uncomfortable, uncertain silence. "Then I'll give you a fact," she said. "If you let my daddy come home, I'll walk into this courtroom on my own two legs the day the surgery is done. That's a fact you can check. You can come watch it happen with your own eyes. I'm not asking you to believe me because I'm sad. I'm asking you to believe me because I'm telling you something that's going to actually happen and you can hold me to it." It was not, of course, legal reasoning. Judge Whitfield knew that better than anyone in the room. A promise from a 7-year-old girl about a future surgical outcome had absolutely no bearing on whether her father had knowingly transported stolen property, and if he were being strictly honest with himself, in the private chamber of his own thinking where 19 years of legal training lived, he should have thanked her for her statement and moved on exactly as he'd told her he would. But something about the specific shape of what she'd said stayed with him through the rest of that day's proceedings, needling at him in a way testimony almost never did anymore. She hadn't asked him for mercy. She hadn't cried, hadn't begged, hadn't performed grief for the benefit of the jury, the way Judge Whitfield had watched dozens of family members perform it over 19 years on the bench. She had made him a specific, falsifiable, deeply strange promise, the kind of promise only a child would think to make, because only a child still believed that the world responded honestly to honest things. That night, Judge Whitfield did something he had never once done in 19 years on the bench. He asked his clerk to pull the medical records that had been filed as part of the sentencing materials, records nobody expected him to actually read in detail, records filed only to establish a sympathetic backstory for a defendant the prosecution had already effectively convicted in the mind of the jury. He read the surgeon's notes. He read the timeline of Emeka Obi's employment history, 2 jobs, 6 years, every paycheck audited by Adaeze's mother, to make sure nothing went anywhere, except into an account earmarked, dollar by dollar, for a surgery in another state. He found, buried in a financial disclosure nobody in the courtroom had bothered to highlight, a fact that changed the entire shape of the case. The $4,000 Emeka had been promised for driving that van was the exact remaining balance needed to complete the surgical fund. Not a round number, not an approximation, but the precise figure down to the dollar. A man planning to knowingly transport stolen goods for profit does not typically negotiate a payment that corresponds, to the penny, with a medical fund he's been building for 6 years. A man who is being told a very specific lie by a person who knows exactly how much desperation he can leverage, however might. The next morning, Judge Whitfield called the prosecution and the defense into his chambers before the jury was seated, and for the first time in the entire trial, he asked a question nobody else had thought to ask out loud. Who had approached Emeka Obi with that job offer, and how had that person known the exact amount of money it would take to make him say yes? It took another 6 weeks of investigation, prompted entirely by that single question, to unravel the truth. That the warehouse supervisor who had offered Emeka the job had done so specifically because he'd seen the medical fund disclosures Emeka had once shown a coworker in a moment of hopeful pride, and had used that information, deliberately and cruelly, to select the one employee in the building desperate enough to drive a van without asking questions. Emeka Obi was acquitted. The supervisor was charged in his place. 14 months later, in the same courtroom, in front of the same judge, who had asked specifically to be present for it, Adaeze Obi stood up from her wheelchair, held her father's hand for balance for exactly the first 4 steps, and then let go of it entirely, walking the rest of the way to the bench on her own. Judge Whitfield did not laugh this time. He simply stood, which court protocol did not require of him, and said nothing at all for a long moment, because there are some facts, he had finally come to understand, that arrive in a courtroom looking like faith, and turn out, when you finally have the courage to check them, to have been facts the entire time.